News just in, the Supreme Court has ruled as moot an injunction application filed by Imani Africa and security expert Professor Ghcelebs to restrain the president from removing the IGP and other security chiefs until a substantive case is determined in May 2025. A five-member panel presided over by Justice Bafo Boni held that the pendency of the case shouldn't stop the president from carrying out his administrative duties, and we'll hear from lawyer Kofi Bentil, who's been reacting to the decision by the court. But let's take you to the Supreme Court right now, where my colleague Lord Eduasare is there for us. Lord, let's try and provide a background with respect to this particular case and why the Supreme Court is ruling. Walk us through the history.
So you'd recall that somewhere last year, Imani Africa and then security expert Professor Ghcelebs filed a joint suit to restrain the president against dismissing security heads, including the IGP. Now, fast forward to early this month, they again filed an injunction after there were reports that the Inspector General of Police, the former, I should say, Dr. George Dampare, was going to be replaced. Now, in court today, the lawyer for both the plaintiffs, Kofi Bentil, moved that injunction application. Now, even before it could start, the panel of justices indicated that his application, the injunction application, is moot, looking at the fact that, as it stands now, that action that he sought to make, the president has already exercised his administrative duty and then appointed a new IGP in the person of Christian Johonu. And so what they didn't understand the remit or why he still wanted to move his application, but he indicated that the application was not, as it were, a personalized one, but it was for the future purposes, so that in future the president will not make such unlawful statement. He indicated that even the letter that was used for that appointment had several issues, among other things. But then the panel of justices indicated that, as far as they're concerned, the injunction application before them had no, for example, statement of case or background story. All they had was that there was an injunction application stopping or trying to restrain the president from doing his job. And considering all that, we're not going to go ahead and give an order against the president or any other person. And so they considered that the application, the injunction application, was moot. And so that's what happened. Now, Kofi Bentil spoke to us. You can listen to him because he was still of the opinion that that cannot be the case. They may have considered it as moot, but there are still certain points of law that will have to be addressed minor.
Let's take a listen to Kofi Bentil in that interaction with journalists.
Supreme Court on your application considering it moot.
But we argued that the matter was not moot. It wasn't moot because, in our view, the order of the president was unlawful. It was unlawful because it sought to overreach the courts. It was unlawful because there are many cases to the effect that when you have a case before the court, you should not take any step to try and overreach the courts, which is exactly what was done. It was also unlawful because the order that was replacing the IGP, at least that's the one that we saw and then we filed, that order, the letter itself, was moot for vagueness. It says replace. Is it a reassignment? Is it a demotion? Is it a retirement? The IG is not at the retirement age. There were many problems even with that letter. So if you add the fact that there was a letter that in our view was unlawful, if you add the fact that the matter was before the court and they shouldn't have done what they did, and then there's another point that I made before the court, that this was calculated to overreach the court and to make the ruling of the court, of no effect. If you take that kind of action, the court must resist it. There are many situations where courts have taken on, or applied their powers to resist such things, and you have a situation like that here. So I was impressing on the court that even though the act has happened, in our view in law, it is void or voidable. And I was trying to impress on the court to take that kind of step, to send a message to everybody. Now, what the court has said is that, well, as far as they are concerned, the process we filed, which will be ruled upon on the 7th of May,
Indeed,
will have a prospective effect. It will have a future effect. And they didn't think that there needs to be any disruption of the purported authority of the president to do what he has done, because that's what has been done all these years. In other words, the court is saying that, well, until they rule that it is unlawful, they are going to assume that what has been done in the past was okay. And to that extent, therefore, they were going to allow the president to do his work. And if the ruling on May 7th happens and it's ruled in our favor, then it will have an effect from now onwards. Okay, so many things were said, but just to try to explain it, the court was reluctant to disrupt the system as it is now. And the court upheld that the president may be acting based on, just the fact that this is what has been done. So until they rule that it is wrong, they assume that the president was acting within the law. If the ruling comes and changes that situation, then whatever happens will be subsequent to today. So in short, that's what has happened.
Fibento is one of the lawyers in that suit where they were seeking to injunct the president from proceeding to sack the IGP and other service chiefs, and the Supreme Court has ruled as moot that injunction application, which came about a week plus ago, and has, amongst many other things, set. We know that May 7 was always going to be the day where a determination on that substantive case was going to be had. Whether or not the practice of presidents sacking security chiefs without recourse to lay down procedure, which is essentially the arguments that they are advancing, is lawful, that will be determined on the 7th of May. But they had sought to injunct the current president, that's President Mahama, from proceeding to sack the IGP, Dr. George Akufu Dampare, who is now outgone, and then the CDS, amongst many other service chiefs, pending the determination of that May 7 substantive case. Well, the president did proceed to relieve the respective service chiefs of their job, and today the court sat on the injunction application, which was seeking to stop the president from taking that action in the first place. The Supreme Court panel says the injunction application is moot. Of these matters, as has been raised by the Attorney General, Dr. Dominic Ayeni, yesterday at that news conference of which we brought you details of. Now, starting off with one of the explanations that's been offered by the lawyers of Mr. Edu Boahen, they say that they cannot fathom why the Attorney General will use the power of the press rather than his advocacy at the bar to feed the general public with his prejudicial and skewed information. And so they hold the view that a lot of the details that was shared by the AG yesterday was prejudicial and skewed to cause public disaffection for their client in the court of public opinion. Now, they proceed to say, amongst many other things, that Iyoko or that it was very unprofessional to assert that the properties purportedly owned by their client, which is Kwabena Edu Boahen and his wife, were acquired after 2018 when there is no verification that they belong to their client using criminal proceeds from their work. Essentially making the argument that all of the 27 plus properties which have been listed by the Attorney General, there's no evidence. Based on what the lawyers of Mr. Edu Boahen are saying, there's no evidence to prove or point to the fact that this was acquired between 2018 and afterwards, and that this is proceeds from criminal proceedings. Again, they have issues with Iyoko denying their client a right to counsel, essentially that they as lawyers could not get access to their clients, and in certain instances when they were even seeking to have privileged conversations with their client, the security officials at Iyoko were insisting on being privy to these conversations which were ongoing between they themselves as lawyers and then Kwabena Edu Boahen and his wife. And then lastly, with respect to conversations about bail and conditions, whether or not that's been granted to them, the lawyers were making the argument yesterday that the Attorney General, when he was addressing that news conference, was acutely aware he had violated the rights of their clients relating to the 48-hour rule incarceration as provided or prescribed by the 1992 Constitution and which was further espoused and clarified by the Supreme Court in Pebu 1 and Pebu 2 as well. But the Deputy Attorney General, Dr. Justice Srimsai, he's been responding to these concerns as raised in the statement by lawyers of Mr. Edubwai in an exclusive interview with my colleague Alfredo Kansi. He says that the Attorney General's office has more than enough evidence to secure a conviction.
The accused person was arrested on Thursday night. Thursday night.
That's Edubwai.
The suspect. We could have announced to the public that moment that he was arrested. But that was the time that we needed to confirm certain things. It was after Friday, Saturday, that we've taken the accused person through. We've granted him his right to counsel, and his lawyers were present. He was shown to various, some of the properties that you see. The accused person has been taken to those properties to verify certain things. The last time I checked this evening, he was still in custody. They've not been formally charged, but they've been cautioned. They're actually on bail. What is left now is for them to fulfill the bail conditions. We cannot put out information merely because someone has said it. We can only put out information when we believe that the evidence we have is sufficient to ground an action in court. In this particular, there are the accused persons are about 50, the suspects are about 15. 15 suspects as of now. And it keeps growing because when you follow the money, it exposes you to another company. Then you find the company directors and members. Then you follow that. So we have more than 12 companies involved here. We cannot put all these things out. In fact, what we have done is just the minimum, exposure that we have given to the facts and the things that we have. If you are surprised by today, what will happen? What you will see in the coming days would even shock your conscience, because you cannot believe what the investigations are revealing.
And so that's Deputy Attorney General Dr. Justice Srimsai providing details really for us with respect to a lot more that is yet to be uncovered with respect to the work that is being done into the activities of Kwabena Edubwai during his time as the director of the National Signals Bureau, working the phone lines to be able to engage Vitus Azim, who is an anti-graft campaigner, with respect to what more we can expect from the AG's office and really what he's made of everything that's transpired. Now the argument is advancing a lot quickly with respect to how and why we continue to see a lot of these infractions with respect to matters in relation to procurement and the likes. There are those as well who make the argument with respect to whether or not in the court of public opinion the AG is seeking to persecute Mr. Edubwai, as has been the argument made by his lawyer Samuel Atachia, who's been writing and making public their grievances with respect to how it all transpired yesterday. But as we speak now, we know that per what the Attorney General has been telling us, there's a 260 million cedis bail with a number of sureties which has been granted to Mr. Edubwai, and then as well his wife, which the argument is that they are yet to meet these bail conditions upon which he will be released. But yesterday as well, the Attorney General, Dr. Dominic Ayeni, provided extra details that he had received fresh briefings which suggested that Mr. Edubwai had to be rearrested after he met his bail conditions. There are those who make the argument that these fresh details upon which a fresh arrest will be made have to be shared so as to not abuse the process of detaining him when bail is readily available to him. But another subject matter of concern, which has got a lot of tongues wagging, has been the properties as acquired by Mr. Edubwai, as has been captured by this details provided by the Attorney General. Let's try and run you through what it is that the AG provided with respect to properties and what the AG says they are looking into, which is on your screen right now, which starts with $1 million property at Mayfair Estates. There is also one with $500,000 which was deposit for five houses at Mayfair Estates. Then there was another $200,000 purchase again at Mayfair Estate. another $270,000 purchase of another house at Mayfair Estate, a $97,815 purchase at Mayfair Estate, $150,000 at Mayfair Estate, and then 27 houses acquired at Vertex Properties, each costing $295,000. And so that's the latest. Let's try and connect right now with Madame Meriada. She is the Executive Director of the Ghana Integrity Initiative, who's she's joined us. She's long called for government to prioritize the passage of the Public Officers Conduct and the Internal Audit Agency bills to help fight corruption. Madam Mary, thank you for speaking to us and for joining us from far away in Kenya. What have you made in relation to the details as has been provided by the Office of the Attorney General vis-a-vis the calls you have made with respect to these bills which are still yet to be brought before Parliament, and then they will be passed and taken to the President for assent?
Thank you very much. Good afternoon to you, Martin. I believe this current expose has vindicated our call that we need a robust and very legitimate regime within which we can all then say that as a people we want to fight corruption. The institutions of states who have been able to do this investigation and come this far would be the better for it if we have a better Conduct of Public Officers Bill in place. That then clearly states the culture of asset declaration, verification, and publication. This gentleman who started work in this place somewhere in, I think, within the other regimes, maybe 2015, 2016 or thereabouts, who now can boast of 27 houses, can boast of 2 of them in outside this country, and can do other things. But that is not to say that we are saying he's guilty, but it calls for a more robust and a very good regime within which this gentleman can now answer the questions. Where did you get these properties from? What is your source of income? And again, we have said the Internal Audit Agency bill is also very important. Let's get it passed. But then the issue about people explaining their sources of wealth cannot be overemphasized.
Right.
It is important that people explain that within 15 years, within 10 years, I was working in this sector, I was able to make this amount of money, and this is legitimate, and these are the sources, and we can track them and call for people to answer if there is a need. Right. And so this is more than evidence that we need to do a lot more and quickly, expeditiously get the Conduct of Public Officers bill passed, and also get the issues around unexplained wealth sorted, and also the issue around doing lifestyle audits. If this were done, I don't think we would have had this challenge whatsoever.
Another issue of concern which has come up is the nature in which it looks like consistently when issues of corruption come up, where we find them. Matters having to do with procurement more often than not tends to be the biggest avenue through which corruption festers in this country. How do we proceed in dealing with this? Because the Public Procurement Authority is expected to serve as the agency which must oversee and grant approvals to when these procurements are done. Yet still, it does appear we have a bigger problem on our hands than it seems, because consistently we're seeing these procurements inflated and leading to monies being embezzled and diverted.
Certainly so. So you see, these regimes are in place to guide our behavior. And so for the public office, one of the good regimes we have in place is the Public Procurement Act. and our current public financial management framework that we have, including the regulation, which clearly spells out what we can do and what we cannot do. But admittedly, you must also then pay attention to the issues around human beings as we are and the selfish nature of every human being and the greed within which we operate. When we realize that we have few gaps in our system, we tend to try to exploit these gaps to our self-seeking advantage. And this has happened over and over again. And this usually would happen in connivance with other public officers who deal in the issues of ensuring compliance. And so for every entity, there is an entity tender committee for procurement. For above that, we have a central tender committee. And so the central tender board is supposed to identify some of these loopholes if they come to them. But then if people have made up their mind that they want to cheat the system, they find a way of doing it together, colluding and finding some of these. And these are intelligent people, mind you, who would be able to do this and get away with it. The person has set up a committee. What are the processes and protocols in place to verify the sources of this and what money is going into it? And then the issue of the private sector actor also comes into being. So if people are procuring and the private sector partner is interested, they also then, because they want to be in business, will allow some of these to come up. He knows he's being cheated, but he wants business next time and allows it to happen. So we as a people need to put in place, as the NACAP said in the first NACAP, put in place effective and efficient systems that detect and report and punish corruption. Right.
Just briefly, with respect to this revelation which we've seen, whether or not it sends a strong signal to persons in this government as well to stay off corruption, because we know that yesterday the Attorney General, Dr. Dominic Ayine, served warning as well to current public officials that he will come after them if they also engage in corruption. Does that come as a big enough deterrent for persons in government now not to engage in such? Just briefly.
Martin, I don't think so. I don't think so. It is a good indicator that there is commitment to fight corruption. And the commitment to fight corruption is usually very good when it comes to doing post-regime accountability. And the new regime or dispensation is in place. You can hold other people to account very well. Yes, it has a deterrent effect on seeing that your predecessor is being held to account and may suffer consequences for it. But then if you look at our space and the way our campaign financing regime is fueled or propelled, then it is very difficult to say that people would be held to account unless we see action. And so we would say that the sweetness of the pudding would be in the eating. Let's see government also hold others accountable. And let's see, particularly for me, I would want to see motivation that people do not want to do this because they see that there is a lot of deterrence and sanctioning in place for others who have tried to do same.
Madam Mariada, thank you very much for speaking to us. She's the Executive Director of the Ghana Integrity Initiative, speaking to us this afternoon.
Now, away from that, former Vice President Dr. Mahama Bawumia is visiting the Blue Light Market today. The popular business hub in Kumasi was ravaged by a monstrous fire on Friday, March 21st, where over 300 shops were gutted in the process. Well, there you have it in your shots. The former vice president waving to the crowd that is there to welcome his visit of the Blue Light Market. Let's connect with William Evans Inkum, who's correspondent on the ground, and find out the latest on this matter. Evans, I appreciate you talking to us this afternoon. The former vice president visited the market earlier today. Well, it seems Evans is frozen in that screen. There you are. Talk to us about what he did today when he visited the Blue Light Market.
Well, Kamini, so he donated 200,000 Ghana cedis to the fracture traders and also donated 1,000 bags of cement. Of course, he also backed them that if they want to rebuild their market, maybe government can offer some guidelines, but they should be allowed to rebuild, their own markets. So that is what Dr. Mahmoud Bawumia is also telling them.
I see. Talk to us about the reception from the traders as well. What was the response to the former vice president?
Well, it was a rousing one. More or less, probably was I think that it was a campaign ground, but I can tell you that the reception was good to him. Again, he also told them that, of course, leaving government, they had done about 80% of the second phase of the KDTR development market project and also ensured, he told government to continue. I'm talking about the current administration to continue. So the traders will also have a better place, to do their business. So it was something that was also welcoming to the traders who also came around him. Of course, he also said something about the fire service and telling them that they did a human job, but they shouldn't be demoralized by some of the things that they've been hearing. It's also something that he also told the fire personnel around.
I see. Let's take a listen to my understanding is that's not ready at the moment, but we know some promises were made to the traders by the incumbent government. Have those promises been fulfilled? What can you report on that?
Well, so we know that some 600,000 have been raised by the current administration. Yesterday, the regional minister engaged with the traders, giving them some level of assurance. Mind you, the traders had early on also raised some concerns about how the market is going to be back to life. Of course, the RTT is also promising them that anything that will make them happy, they are also in line with them. Of course, this morning, Sanchene also delegated some troops to also come and ascertain the veracity of the extent of damage and also they engage traders as to exactly what they want done as far as rebuilding the blue light market is concerned. But coming in, trust me that even if the blue light market is going to be built, we are not going to see it as it was before the disaster. There's going to be proper planning as far as bringing the market back to life, because it's something that we are also getting from government.
I know the scope of damage as far as this market is concerned. What are the investigations showing us?
Well, now we are getting varying reports. We cannot independently confirm because the traders believe that Ubisoft might have caused this particular destruction. Of course, when Dr. Mahmoud Bawumia came, he also mentioned that as something that he is also hearing. We have not been privy to any official report from the fire service, through the RCC or the Regional Security Council as to what really triggered 21st March Afenyo at the blue market inside again. But we understand that investigation is still ongoing, even including forensics, just to be sure what triggered the laser fire.
Very well, Evans, we'll leave it here. Thank you so much for talking to us. William Evans Inkum is our Shanti region correspondent. Now, Ghana is battling a growing fire crisis with frequent outbreaks reducing markets, homes,